My name is Trent Bosgra, and this is my Global Law Week 7 submission. Courtesy of my hostel, currently I'm having accommodation challenged. So we have my nice hostel room as the backdrop for today's video. Week 7. So this week is concerned with sources of international law. And the first question relates that we have to answer is what is customary international law and what elements have to be shown for it to exist. Customary international law is a source of public international law. It is listed as one of the sources of law which the International Court of Justice, can use in deciding cases that come before it. Specifically in Article 8 of the Statute of the International Court of Justice lists the customary law as well as treaties and general principles of law as formal sources of law. It also lists there that previous judicial decisions of the court and published academic teachings are also able to be used in adjudicating cases. However, judicial decisions and previous judicial decisions and academic writing on international law are used in practice not as formal sources of law, but as tools to elucidate the specific content of the other three sources of international law, what they are. Perhaps, what a treaty says, or specifically to help elucidate whether a customary international law does exist, but they are not formal sources of law. However, I digress. Honing in on that first formal source of law, the customary international law. What is it? Specifically, we know that it's a law, but specifically, it is, as it suggests in its name, custom. It is a pattern of behavior that can be seen to be a general practice which should be binding in analogous situations. To put it another way, it is a pattern of behavior among a group of international states, a modus operandi, perhaps, that goes on to create law. Now, for a party before the International Court of Justice wanting to establish that there is customary international law, either to prevent another state party from doing something or to justify and enable it to do something, it must establish two things. It must establish that the customary law, to establish customary law, it must establish that there is a state practice, and secondly, it must establish that state practice was done with a sense of legal obligation to have done so. And that second element is also encapsulated by the Latin term opinio juris. Has to be accepted as law. Going to the first element, state practice, to be able to identify this is the custom, and to be able to identify the custom or state practice, as the first element is termed, the court will look at positive acts of states, omissions and acquiescences of state actors, and obviously the state is an abstract legal person, and so what we're looking at is the human being actors here within a country, and so evidence is gathered from material acts of the state, for example, what they do, what the government goes out and do, government officials do on behalf of the countries. Speeches are also taken into account of state officials. Domestic legislation and court decisions also help figure out a state's position on an international matter and how they are acting domestically and whether that aligns with an international practice. Also, policy documents and press releases are able to be taken into account. Now, a custom cannot be a single one-off event, of course. It must be shown that it's done a number of times, but to what level exactly? Well, the International Court of Justice has explained that for it to be a state practice, the acts or the practice must be done in a consistent and uniform way. Not absolute conformity with past acts needs to be shown. There can be occasional departures from the practice, but by and large, the practice must be extensive and virtually uniform to be considered a general practice. And that was borne out in Columbus, and the case of Columbus and Peru in 1950, where Colombia and Peru, where Colombia was trying to give political refuge to a person who incited a coup in Peru, and Colombia argued that it was international customary law, that they could give refuge to political refuge of this kind. But the International Court of Justice found that in that instance, it was not able to discern whether there was a constant and uniform usage mutually accepted as law. So there were too many events that Colombia pointed to that were inconsistent or fluctuating. So it didn't reach the bar that is required there. So another aspect to having some level of consistency in practice is that it must be widespread and representative. It doesn't have to be universal, but the practice must be more ubiquitous. It is an international stage after all. So there's no set number on how many times this must have occurred or how many states have done it, but the more widespread it is, the more likely it is to meet this requirement. In particular, it could be the court could look at how many parties signed a particular treaty, and the more parties that have signed on to a particular treaty and a particular way of operating is definitely in favour of a finding of customary international law. So yes, the acts must be uniform and extensive. The acts must be widespread and representative on the international stage, and there's no absolute conformity required. Also, the duration, the time the practice has been going on for, is not necessarily it's not necessarily something that will destroy a finding of the existence of an international customary international law. So that's the first element. We've found the what, so we've looked at what the custom is. The second element is that practice must have been done or carried out by states because they believe that there was a legal obligation to have done so. And this second part poses a lot more, is a bit tricky. because it's hard to look into a state's mind to determine why they have been acting that way. They could have been acting out of politeness or out of courtesy, or they could have been acting because they thought they were legally obliged to. So, evidence of this opinio juris can be found in the UN General Assembly resolutions, and those resolutions might show a state's attitude towards their previous acts and show that they thought that they were legally obliged to. Domestic legislation is also a really good one, treaties entered into. But it is hard to establish that in that regard, this source of international law in that regard, because potentially, I think a question that could be posed is, from the beginning, a party may have been doing something because it was polite. At what point did they carry out those acts because they thought they were legally obliged to? So there is some difficulty in it. Now, there is an exception to the law, and that is persistent and clear objection to the customary law, evidencing a contracting out by the state at the time the customary law was developing. And this is interesting. I guess an interesting point to make here is that customary law, unlike treaty law, applies to everyone, whereas treaties bind the consenting signatories, but customary law binds all nation states. So, clear and consistent objection must be done when it's starting to form in that international stage, because it's going to apply to everyone, right? So there must be, clear acts of objection, establishing that state has contracted out of it and therefore it doesn't apply to them. It must be done while it's on the rise, because once it's crystallized, once the customary law is crystallized, then you can't just go and breach it and object to it and say, oh, we've contracted out, because you're just breaching the international customary law at that point. So, yeah, interesting point. That is international customary law and its exception. The second question is, what is the significance of International Court of Justice decisions in public international law? Are they binding on states, and how do they operate as a source of law compared to High Court of Australia decisions? Like I mentioned earlier in this, sorry, I'm running out of time. The decision's not binding, so they do not bind future analogous decisions that come before the court. They bind only the parties that are subject to the decision. However, the court decision can help guide the Court of International Justice in the future, and it's used to really. Previous decisions are really used to help the court identify what the law, what the sources of law mean, but it doesn't bind the court to decide decisions in an analogous way or exactly how they were. And that is the key separator between that and the High Court of Australia decisions, because once a decision is handed down by the highest court in Australia, by the High Court, all other lower courts are bound by it, and future decisions moving forward must be decided in line with that principle. Obviously, the High Court of Australia isn't bound by its own decisions, but it does have a very powerful binding effect. So, yeah, that is my submission for this week. And, Trent signing off. Thank you.